Well, yeah, go ahead.
Okay,
I'll just introduce me, thank you.
Okay, because he might know, yeah, this is John Stalberg, does a lot of workers' comp. He was a fellow in the program back about 38 years ago.
Last century.
Yeah.
Wait a minute.
Post-Civil War. And he is gracious enough to come in today to talk to you about workers' comp. He's probably the #1 guy in workers' comp in doing the evaluations. Been doing it for a long time. And he fits right into it because you had Shapiro, then you had the Judge Kolditz, he knows all these players. And now it's his turn. Then we're going to have Brian Jacks next week because he's doing a lot of it now. And then John's going to come back for
Part two.
For part two.
And I'll discuss the cases.
Right, and then we'll give you an opportunity to even go to somebody's office to actually do one.
Oh, yeah, that's good.
That's what we're going to do with
Yeah, that's great.
And to do it doesn't have to be a real one, but I mean, you'll actually see the real case. And John's got some cards he's going to hand out to you, some
Cards
and
and a
stuff.
pen for my website, if anybody's interested.
He's,
Roberto?
yeah, there you
Yes,
go.
now?
Yes.
John did his residency here. He'll tell you all about the background if you
Yeah.
want to know about it. But, oh, here it is.
Let me thank you for showing up, and I know it's not a big crowd, you might think I did too much, but you know, once you do this, it's permanent, and my cameraman there.
Did a good job on that.
Thanks.
Keep it in red and all.
Yeah, Roberto's my man for that. And by the way, questions are welcome, so at any time anybody has a question, interrupt, please, because then otherwise you
What does this bring back? Old memories?
forgot. Yeah, so these are just real quick here. You gotta be, remember you have to be board certified in psychiatry to be forensically second. And this was way back, which this board doesn't exist anymore, right? It's replaced by the American Psychiatric Association with the new one with,
Right.
what's it?
ACT
Credentials.
with the,
American Board of Psychiatry and Neurology.
yeah.
What's it considered?
American Board of Psychiatry and Neurology.
But with credentials.
Forensic psychiatry.
All right, there's undergraduate up there, and then, I don't know if I'm a glutton for punishment or what, but I'm like Bruce, I'm an attorney as well. I'm a member of the bar, but I don't practice.
Okay.
So I'm not here giving out any legal advice, because I never had a client yet. And I got my practice up there, what I've done. I was telling Bruce before, I spent half of my third year, we got 10 months elective. So I was here 5 months, and I was Santa Monica West 5, then I liked that, and I was there a couple of years. And I came here for 5, so I actually doing a year here.
6 or 7 years. Did that person commit murder on that gal when you were there?
The murder was around 90. I wasn't there. Yeah, a patient there did murder somebody. There was no security out there. Then they used that along with the Northridge 94 earthquake.
I was
to shut it down.
Yeah, okay.
And then I was a staff psychiatrist. That was just a moonlighting job down at Metropolitan State. Interesting to work in a state hospital to see how they move them in and out. About $1,000 a month, Bruce.
Yeah.
That's just my background. And then over here, I think Central Probation, Central Juvenile Hall is still there, right, Tim?
Yes, still there.
East Lake.
Uh-huh.
That was not as a regular, that was not psych, that was doing regular medicine, believe it or not. So that's nice because when attorneys cross-examining and they say, you don't know medicine. I said, well, yes, I do. Besides going through County USC, of course. And then medical, yeah, St. John's, it's interesting, this says a lot. St. John's psych program, gone. They took, you see where they ended, 93.
They ended in 93,
And then we
right.
got the January 94 earthquake. And then Brotman, I think, is around a little bit. Who just closed this year? Does anybody know whose psych unit closed this year? Big one
Besides
out there?
Cedars.
Be Cedars, yeah. Cedars Sinai shut down because my mother-in-law's a nurse at the hospital,
Okay.
and she says nobody in there had any money, so they shut it down.
Yeah.
So I did my rotating internship here in '71.
71 it was rotating before they did away with the
R6.
rotating.
Yeah, that's done away with. Okay.
It's done away with the rotating now.
Then psych residency here for 3 years.
Yeah.
And then a fellowship with the late, great, I call him great Seymour Pollack.
Right.
I learned more from him than
Yeah.
I think you could learn from anybody. Then this is what we had to do with the supervision, as I was saying, for 2 months we had to do. I did a little hypnosis in my time as well. I don't do that anymore. I actually instructed here a little bit around that time, Bruce, 76 to 84, come by, interviewing. And right now, I'm strictly private practice, and my work is probably like Dr. Jacks is going to be here next week. I can't speak for him, but probably 99% work comp.
Yes, Brian's trained as a child psychiatrist also, so he spends at least 6 months teaching in the child area, and Brian is giving up most of that custody stuff.
It's tough.
It's tough.
You know,
Everybody threatens your life.
well, yeah, that's, when you do hear about shootings at a deposition, it's usually a family law,
Yeah,
custody
family law.
dispute, right? So I treat a lot of, and I say thousands, I mean, that's just rough. I'm still on the psychiatric criminal panel, but yeah, I do less and less of that. Actually, believe it or not, I went over to the Old Bailey and testified at Arthur Jackson, who attacked Teresa Saldana. So you get some interesting cases. Actually, I probably did one thing I shouldn't have done. I went over to examine Bardo in Tucson, Arizona, the guy who killed Rebecca Schaefer.
Yes.
Which may not be legal anymore, because I don't have an Arizona license. What am I doing over there? That's considered practicing medicine, right?
Correct.
So actually,
Yeah.
I was
Yeah,
practicing,
Yeah.
it was 89, 90, so nobody said, don't do that.
Bartle, he worked at Jack in the Box. Actually, his mother worked at Jack in the Box.
Oh, did she? Okay,
Yeah,
you know.
Yeah.
Most of my cases, I'm an agreed medical evaluator. I'll get into what that is, and I got the Old Bailey up there, which is interesting. Everybody in the room with a wig, they gave me a robe. It was, I didn't have a wig, but U.S. District Court Psychiatric Panel, I don't think I can't remember, a couple of years ago since I've done anything with that. Superior Court, maybe 3 or 4 this year. IME is gone. IME is now called,
Agreed.
no, it's called regular physician, because workers' comp wants to get away from putting us in the forensic box.
Okay.
So we want to be like Marcus Welby. I got a call once from a judge, and I said, well, I appointed you as a regular physician. I said, well, I'm a regular guy. She laughed. She said, no, I mean, that's what it is now. IME is wiped out.
Okay.
But it was that way back. And there's a qualified medical examiner. There was an appointment, and then there was a test that came out in June of '94. It's not that hard. If you pay attention today, I'm not saying this is the whole test, but it's basic stuff. And so that's what I've been doing, and now it's...
Can I ask why are you
Yeah.
trying to go to law school?
The first one would be like, because I like it. I like the law. Number one. Number two, I thought it would give me extra clout in court. But, you know, a lot of attorneys don't want you to tell the jury you're a lawyer because they say juries don't like lawyers. So I said, all right. But I think lawyers appreciate the fact that you've passed the bar. It's more than just going to law school. I took the bar, passed the bar, licensed, and I think they do, my deposition's taken a lot. That's the way workers' comp works. I'll talk about that. But I think probably the older attorneys think you're crazy for doing it, but the younger guys are impressed by it.
They're impressed.
Yeah, right?
Vickery, because he went to law school before he went to medical school. And I remember him when he was in medical school.
Yeah, he went the reverse. He's JD, MD. Most
Yeah.
of us are MD.
He went to Harvard, and he
Yeah.
said, but he never practiced.
Yeah.
But when he goes to depositions and stuff, he always has to look down, because they ask him, "Are you know anything about the law?" Yeah.
Well, I also got tired of the attorneys who would take my deposition. I'd probably take it 3 times a week, because that's the way it is in workers' comp. There's no juries, you know. They don't want doctors going to the board. So they sit there with a court reporter, and I got tired of them telling me, you leave the law to us, and you just answer the medical questions. But in workers' comp, they're so intertwined. It's like answering the issue of competency to stand trial or insanity. Unless you know the legal test, you can't answer any of these questions.
Right.
And I'll talk about that more when I come back, about all these cases.
Tim, you want to sit here? No? Okay.
Let me get started now with why workers' comp systems were established. Well, there's too many cases to be handled in court. The last time I checked, there's well over 1 million a year of workers' comp, probably with attorneys. And this court system, just in the state of California, because there's 50 different workers' comp sets of laws, and there's about another 10 federal on top of that, depending where you are at the dock, the boat, going to the boat, or on a railroad car fighting civilian in Syria, or over the Middle East. So there's too many cases, number one. And also, let's say an injured worker, he's injured now, so he's got no income, certainly has none for a while. So you can go get an attorney in workers' comp, or you can make a claim, let's say, to whatever insurance company it is, let's say Travelers. That doesn't cost any money. To sue somebody costs money. To make a workers' comp claim with or without an attorney doesn't cost anything. So there's no upfront money. Negligence is irrelevant. Basically, it's a no-fault system. Now, the reason I put the word generally up there are some exceptions. If you're drunk and get hurt, it's tough to prove, or you're on drugs, or you're engaged in these old-fashioned terms of skylarking or horseplay. Skylarking and horseplay just mean fooling around. So if you're doing that, and they can prove it, it's hard to prove. And as also supposedly, and I understand that there are many cases that anybody could find. I think I just saw somebody who was hurt in 1987. Isn't that 25 years ago? So it's possible that this drags on forever. But it's at least in LA County, and probably less, it's more slow now because the courts are closed. But there it's at least 5 years, and workers' comp is supposed to be over and wrapped up. Theoretically, it was started to be wrapped up in a few months. It takes much longer than that. And also the need for treatment. Let's say somebody breaks their leg at work. Well, you can't get attorneys and fight it out and argue in front of a judge anytime your leg is broken or you've had a heart attack. So the need for quicker treatment, it does get you that. Although, I know there are a lot of criticisms about workers' comp. I know there's all new laws coming in January that will affect next year. A lot of it is questionably whether it's legal, but I'm not going to get into that now. It's premature. But anyway, these are everything I'm going to discuss today. It has to do with people who have been hurt in the past or people who were hurt through midnight on December 31st this year, because the law may change a little bit after that. So that's the reasons why we have it. And by the way, if you wonder when it was, I think in this state it was about 100 years ago, early 1900s. Now, what type of benefits are offered in workers' comp? Well, you see a dollar bill up there. It's not just money. It's temporary disability. So if you're making $300 a week, temporary disability is 2/3 of that. So 200, 2/3 of that. You would get treatment supposedly right away. I know the insurance companies can always say, fight it. Everything can be fought, obviously, you know that. But get you quicker treatment, pay you the temporary disability. Then if you have, let's say, a permanent injury, you get a damaged leg, lose vision in an eye, or so on and so forth, then your ability to compete in the open labor market is reduced. So there's a complicated formula for that. Vocational rehab. See that up there, and I said cancel, because it's only fairly recently when Governor Schwarzenegger was sort of in charge, and he pushed the legislature to basically do away with it. So now you can get anywhere, the injured worker can get anywhere from $4,000 to $10,000. It's called job displacement benefits, depending on how much money, how disabled they are actually, combined with their wages. Death benefits is pretty important, because you hear about these injuries when people get killed. What happens? Well, they can't have a case because they're dead. Well, their wife or their dependents has a case, and that's another area where the benefits are offered. Now, I'll talk about this when I come back in January. What about a suicide? That's very complicated. I'm not going to get into that now. But death benefits, and that'll be fought for sure. Now, how is workers' comp organized? We got the Division of Industrial Relations. They do things like Cal OSHA, other employment law. They oversee various other things. But the main thing that the Division of Industrial Relations oversees is the Division of Workers' Comp. And that's in San Francisco. And then it's the Workers' Comp Appeals Board. I don't have all the boards with me. They're usually in this area, for example. We got the biggest one in the state is Van Nuys. What does big mean? Well, most judges. You got Van Nuys, the Marina, downtown LA, Long Beach. And then we got the Industrial Medical Council, and look at that. I think it may be misspelled up there, isn't it? Anyway, the IMC now is eliminated. So it's in some ways it's a silly system. It's all legislatively created, and when something is not liked, especially during a bad economy, what gets attacked as the root cause of it is workers' comp. So the doctors were pretty much, their input was eliminated with that. You see what's eliminated up there. With the last slide, voc rehab. Now the Industrial Medical Council's gone, which are all doctors. What are the trade-offs between the employers and the employees? Well, as I said before, there's no jury. So you don't have to wait for that. And there's no jury, and it's just a judge. And way back when it started, it's hard to believe, the judge didn't even have to be a lawyer. Now they have to be at least, they have to be a lawyer, I think, for 10 years. The trade-off is you can't sue for like hundreds of millions, or let's say 10 million, you know, a high figure, because you have this trade-off where there's no fault, so you get less money, and you can't go outside workers' comp except in different circumstances. That's complicated as well. But you have a certain amount of benefits that the insurance company has to pay. And when I say the insurance company, I also mean companies that are self-insured, that usually someone who will handle the paperwork. So does anybody, any questions about, or what is the exclusive remedy? Anybody know? I mean, you can only go to workers' comp. In other words, if you're working for McDonald's and somebody spills something on your clothes and hurts your knee, and you go to the emergency room and you slip and you go to the emergency room, it's $100. You can't take McDonald's to small claims court. You can only go to workers' comp. You can only go to the workers' comp board or get a lawyer to do it for you. He won't do it for a case like that. Now, what's the burden of proof in workers' comp? It's like the civil standard, preponderance of the evidence, which is over 50%. Burden generally on the injured worker, because you have to prove you're injured at work. You have to prove that's, you know, what happened, and I'll describe that in a minute, arising out of or in the course of employment. Now, it's on the employer regarding apportionment and causation. So they might say, the employer might say, well, wait a minute, you claim that you hurt your back at work, but we have records that show you were hired with a bad back, and it's no worse now than it was then. So then the employer would have to prove that. Or it could say psychiatrically, you've suffered from major depression before, a certain level of disability, and you're no different now. So that would be the burden on them, the employer. Now, what is in a forensic psychiatric report? Let me find it here. Well, it's the usual laundry list, you know. Background, past history, present history, how the injury happened, family history, and the state is very concerned with other people doing your work for you. So you have to list who does the work in a report. Who does the work, where it happened, how long it took. I have to even refer to these notes myself because I can't remember everything they want. I mean, they want so much, but it takes a long time to do it, and then when you bill them for your time, they frequently get annoyed that it took you that long to do it. And then, by the way, the word perjury occurs in the reports, I think 9 times above your name, to make sure that everything you've done is ethical, you're not lying or not exaggerating about anything, and as far as you know, it's really to cut down on fraud. That's why the word perjury is in there. So it's the usual laundry list. What kind of treatment you need, of course. Used to be voc rehab. And then, of course, this is the important one here, the second one, that they finally realized, they being the state, well, you know, we realize that these doctors are giving these conclusory opinions. So it's called substantial evidence is the word they use, the words they use. And it must be, you know, the way we use it here, right? You give all your reasons for your opinions, right? So that's what you do here. And it's called substantial evidence. And cases get kicked for 2 reasons or reversed by, it's not a court of appeals, but the Workers' Comp Board in San Francisco. That's another part of the board. And they sort of like an appeals court. And they'll give usually 2 reasons. The doctor didn't give substantial evidence, he didn't back up his opinions, he just came to conclusions. Or he didn't understand the law. He didn't understand apportionment, didn't describe it correctly. Now, compensability issues. What constitutes an injury? AOE, COE, arising out of employment or in the course of employment. So it has to be one or the other. Now, what is arising out of employment? Again, I'm getting away from the psych just to make it more simple. If a man whose job is to dig ditches hurts his back while he's digging the holes, that's arising out of employment. If it were not for the digging of the ditch, digging of the hole, he wouldn't be injured. Now, what about the case of the guy who his boss says, okay, it's lunchtime now, you guys get an hour off, and And for the convenience of the company, I don't know what you guys doing, going too far, but there's a McDonald's over there you can go to. So these guys now aren't working, but they're on the company, well, like I said, for the convenience of the company, they don't want you going too far. So you're walking over to McDonald's, and when you're on the way, you should get hit by a car. That's in the course of employment. That's what that means. You're still on the clock, and it's for the convenience of the employer. Derivative injury is a little bit different, actually a lot different. That would be, let's say you're getting, you treated for a torn meniscus, and you're given anti-inflammatories, and maybe surgery's not scheduled yet, and you then develop an ulcer because of the non-steroidal anti-inflammatories, the Motrin. That's a derivative injury, so now you have another injury. And then on top of that, let's say you get depressed. So now you have a bad knee, you got bad stomach, and now you've got depression. So their derivative injuries are compensable. And that's also reaction to medical care would be the third one as well. That would be medication side effects. Or let's say you're getting operated on, and the insurance company, Travelers, agrees, oh yeah, he's got torn cartilage, and it's work-related, it's work-caused, so we're going to pay for it. You get admitted to the hospital, and then there's some terrible thing that happens in the emergency, in the operating room. So that would be, let's say you have a stroke or something, the patient does. So that would be all an injury. Interestingly enough, too, if the insurance company, and I see this happening a fair amount, if they've agreed that you can go to a certain medical visit, if you're in a traffic accident on the way to the visit, that's part of the work. That's another work injury. Let's say you slip and fall on the way to that doctor visit. That's, again, that wouldn't be a reaction to medical care, but that would be because you're doing something, and the way the courts look at it, it makes sense. But for your industrial injury, you wouldn't be going to the doctor that day, and therefore you wouldn't have gotten into that traffic accident. So all that's an injury. And there's, again, a couple more types. As I said, arising out of employment, AOE and COE. Arising out of, it means the actual activities of the job. And you're probably sitting there wondering, what about psych? What about a cop who's under stress 24/7, not 24/7, but 12, works 12-hour shifts usually. So there's a mental stress from that. You're a substitute teacher in a rough area. That's constant pressure from 40 kids yelling and screaming. I've done that in my time, substitute teaching. In the course of employment, again, that means, let's say, okay, it's in between classes at the school, and you're walking down to the faculty room for a coffee break. If you slip and get hurt, that's work-related because you're there at the job site. Actually, the work-relatedness starts out, let's say you drive, from the minute you enter the employer's property. When you drive into the parking lot, if anything happens after that, on the way to, I've seen people get hurt on the way from the car to the elevator on the first day of work. They haven't even punched in yet, and they have a compensable injury because it was in the course of employment. Now, have I ever seen when a guy will come in Monday and claim he's got a bad back after an hour of work when he actually hurt himself the day before? Sure it would. But that gets into the whole litigation and discovery aspect of the case. And there's not as much fraud, I'll tell you that. I think most attorneys would agree. There's not nearly as much fraud as the politicians will say. I'm not saying there's none, but it's not to the high extent that I think got Schwarzenegger even elected on the platform of cutting down on workers' comp fraud. And he blamed everybody, attorneys, doctors, and the workers. But it never seems to go the other way, where it's the insurance company who's engaging in the fraud. By the way, workers' comp fraud is a felony, so that's over the past, I think since '93. So what is a compensable injury? Now there are some, well actually there's a law, the law I said pending is going to put some limits, at least initially, to a psychiatric reaction to a physical injury. And this is going to be litigated forever, and not forever, for years, and it's going to be a long time. So, like I said, it's going to be weird when they're accepting a straight psychiatric claim, you get depressed because, or get anxious because the kids are driving you crazy in the classroom, that's okay. But if you get upset after you failed back surgery, that's not going to be compensable. And there are a lot of exceptions to that too. If it's a crime of violence or sudden or catastrophic is the word they use too. There must be an employment relationship. In other words, if you're a private contractor, I have a couple private contractors. They come by and pick up stuff when they want to. They deliver it back when they want to. They're not really my employees per se. They're private contractors. So if they get hurt on the way in, or on the way out, or something happens, I have no relationship with them from an employment point of view. So I don't really owe them workers' comp coverage, so to speak. And then, of course, you need, as I said before, and there it is up there, those words again, AOE, COE. And some of those are going to come down to a battle, you know. Was he really working? And then every possible thing that you can think of has been litigated. The guy who, during the company picnic, twists his knee and needs surgery. Well, what was he doing at the picnic? He didn't really have to go. So the issue was then, did your boss want you to go, or did you just choose to go for fun? And then it just goes on forever and ever. I think there's a personal comfort doctrine. If you're taking a cigarette break, I know people are not smoking much anymore, and you pull a muscle while you're smoking, that, believe it or not, is workers' comp, is compensable. There was an issue that was fought. I don't think the case got published, but I did see it, where there was some sexual activity, and the worker used the defense of he argued it was for the personal comfort. And it was never published, but he lost that. He didn't win that argument. Roberta, how many pages were there?
I think we're at, I think it's 34.
Okay.
Some of them are just title pages.
Yeah. So, are there any questions that anybody has right now? I don't want to, we got plenty of time. We'll take a break in a little while. I'm going to talk about some books I have here. Oh, by the way, here's something too that I wrote down. If anybody's interested, a lot of the documents and a lot of the stuff I'm talking about, of course it's all over the internet, but this is, if you're interested, this is the website, www.dir.ca.gov. www.dir.ca.gov. Okay, you can jot that down in the card. And I wanted to take this opportunity as well to mention this thing. It just happened yesterday. Does anybody here read the LA Times? Probably not. I bet nobody reads it anymore.
Not regularly.
Yeah, I mean, people don't read the newspaper, right? You look at your internet. Anyway, these are the top-rated lawyers. Does it mean anything? Nah, because lawyers probably get, they probably were important at it. And, they were the guys who said that this is who, I'm important because I say I am, right? But this is what these guys practice. And needless to say, workers' comp is at the bottom. Workers' comp attorneys are looked down upon. They're seen almost as they said, bottom dwellers and not being too bright. But actually, workers' comp is pretty difficult, and you can get special certification as an attorney. But these are the guys that think they're, business, commercial, civil litigation, finance, personal injury, product liability. The guys who are in for a lot of the money. There's only two guys in here, I'm not going to give their names, who are mentioned as workers' comp lawyers. One guy says, I only see cops. And one guy says, I only handle it's obviously he handles only very terrible, very costly injuries. So most of the attorneys really, it's not, I'll admit that it's not very glamorous or romantic. It's not like we see on TV, Law and Order, criminal stuff, other major stuff, the practice and all that stuff, medical malpractice. But there's a lot of workers' comp attorneys that are bright fellows, and there are a lot that, just like anything else, there's some smart ones and some that are not as sharp. But I think to look down upon when you get in the system and you see, and especially next time when I can know all the cases and all. I mean, here's the California Labor Code. That's one of the books I listed. This California Labor Code, and this is 2012 edition. I mean, there's a lot to know in here. And There's a whole section of the labor code and then the administrative regs that following that. But I mean, that's one of the books I put on my list. But this stuff is extremely complicated, and I know, again, I know that if somebody says, well, I want to go to law school because I like workers' comp, other people think, well, that's, you just guys just shuffling papers and not, it's not really romantic. I mean, you don't argue a case to a judge. I mean, not jury. You argue to a judge, and it's casual. These are a couple other books I put on the list. I don't, did Bruce give you the list of other books I put down there? There are a couple nice books here. I'll just pass out and you can take a look. Here's the labor code. Take a look at that while I'm talking. Here's a very nice one I picked up. This is really written for, it's actually, interestingly enough, I think it's the old line, you know. A client who becomes his own attorney is a fool for a client. This is written for workers who are going to handle their own claim. I got it because I wanted to see what, and the guy knows the law pretty well, but I think anybody other than a minor, real minor, almost a first aid kind of injury, who doesn't get an attorney, I think is making a mistake. But this is a good book if anybody's interested in it and outlining it. And the amount of paperwork in workers' comp, unfortunately, is monstrous. Is really the amount of papers that you must fill out and provide, and it's very difficult. But this tells a worker what to. I was looking at it, and it's actually a very well written book. If anybody's interested, I have nothing to do with it as far as making any money. And here's another one I checked out. One of the ones on my list, for some reason, it's not available. This is a good one here too, and this is written by, I think this is written by a doctor nearby. It's a nice book too, Strategies in Workers' Comp. And, you know, it'll show you that the stuff is not really all that simple. And the other book I noticed on your shelf, the AMA Guides. But AMA Guides, that became the law as a 1105. In workers' comp, you must follow the AMA Guides. Why? Because they have numbers. You need numbers, right? And the other thing is, the AMA Guides are more conservative. Probably nobody even knew that until you get into it. It's more of a written by defense or insurance doctors. And the AMA Guides didn't know what to do with psychiatry. So you know what we got referred to, or where we were sent by the state? To GAF. We'll get to that later. Does anybody know what GAF stands for? Global Assessment of Function, right? It's in the DSM. You don't use it much, though, right?
We do.
You do use it a little bit? Now, you'll see, I'll show you the table before. That's later. So that's what we use from the GAF to a whole person impairment. And, you know, there's so much emphasis on evidence-based medicine and the substantial evidence. And I put in my reports now routinely, I criticize that. I just said a GAF of 60 is a whole person impairment of 15% because some bureaucrat says it is. Who's to say how much it is? But I'm surprised you use GAF. What do you use it for? Just patients who come through?
Yeah,
Routine?
every evaluation.
Really? You
I
do?
don't think insurance requires it.
Oh, insurance requires it, yeah.
Just kind of depends what you rule, where someone with a gap less than 40 is usually inpatient
Oh, okay.
eligible. And
So some outpatients come through here? Psych outpatients? Is this?
probably, I mean, in the clinic here, we don't see
Oh, you don't see them?
patients now.
Oh, I see. Okay. Yeah, I took when I did the fellowship, it was over there at 1237 North Mission. So one end was the outpatient, at the other end was the psych and law. But I think insurance companies like to see, too, that the person had a gap of 40 when they were admitted and a gap of 60 when they were discharged, right? They say, wow, looking at numbers, that means they got better when they were in the hospital. Anyway, that's what we have to use in workers' comp. Is that a good system? No. But when now I'm not saying GAF's not good. To rate disability it is, because they specifically state in the DSM-4 TR that it's not to rate disability in the cautionary statement, and that's what the state says we have to do. But there was a doctor, a psychologist, of course, in 1988 who said that disability should be rated by giving everybody an MMPI, and we'll rate the disability by the spikes on the MMPI. Depression, hypochondriasis, schizophrenic scale, depression scale. And of course, that might have gotten through because psychologists have a lot, number one, they're defined as physicians by the labor code. And they have somehow, because of their testing, which is paper and pencil testing, but they're able to convince some judges and some other people that was like an objective X-ray or EKG or blood test. I have a lot to say about that, but not today. But luckily, that was not used. And there are a lot of psychiatrists showed up at that meeting, and we said, no, the MMPI is not the way to test disability. Okay, so we have by the way, compensable injury up there, it says must have an initial physical injury. That's for the compensable consequence of the psych. Obviously, if you're a bank teller who's robbed, or someone, like I said, a police officer who was shot at, or something else happens at work. I just saw somebody who worked at the 99-cent store on Reseda Boulevard in the Valley. A car comes crashing through the window and almost ran over her. Well, of course, she's going to have a reaction to PTSD, which she did. And there was no physical injury, but it was psychiatric. Let's see. I left it too long on page 15. What do I do now, Trisco?
Let's stop moving forward.
Stop moving. Can we stop it for a minute? A little help? Thanks. Sorry about that. Roberto's here because he helped me get my...
I'm the non-tech.
Yeah, it should work now.
Is it working?
It should work.
What happened?
Something popped up.
Okay. Okay. Now, this was scheduled from 3 to 5, I believe, right? So we'll take a break in a few minutes, and then we'll come back for the second half, all right? Is that the way you normally?
Sounds good.
Okay. I'm going back. Okay, let's see. All right, the date of injury computed. You might say, well, what the heck does that matter? Well, that matters because what if Travelers is, I'm just using Travelers as an example, they're insuring it from January to June 1st, and then June 1st, another company took over. So we have to know who the insurance company is. If it was a simple slip and fall, let's say, it's not that complicated. But what if it's a factory worker who just basically, or a secretary who gets carpal tunnel, just wears her hands out? Well, then it's continuous trauma, and you go back to the first day of the trauma, supposedly. That's argued a lot, but that's how it works. And that becomes important for basically who's covering the accident. Because insurance companies are changing all the time, and a company will go from being self-insured to insured, or the other way around. So that's how. Also, that's important for what? Statute of limitation purposes, right? Because a worker has 1 year to file a claim. Is it a 1 year from his injury? Well, usually. But it's the old scenario, what's reasonable and what he knew or should have known. What if he had asbestos exposure but didn't know it? And then now he makes the claim, so it really can go over a year. But it's usually 1 year. 1 year to make a claim. Or the statute, that's it, it's too late. But judges are very lenient with that, and they'll often find a reason. Well, he was depressed, he was anxious, he didn't know what he was doing, he was confused, and if he doesn't have much, he'll get a doctor perhaps to say that sometimes. Now, here's the interesting thing, causation, which again, this changed in 2004. What is causation? Well, basically, the way I look at it is, here's the employee, John Doe. He has an injury. What caused the injury? What was what happened right before that resulted in the injury? Or would his heart be the same? Would his back be the same? Would the secretary's wrist be the same absent employment? If you could say, yes, he'd be the same. His back was shot. We x-rayed his back. He was osteoarthritis in every joint, bad discs all over the place. We can't point to anything really that happened at work. Then perhaps there wouldn't be causation. And the level, again, before, like I said, is 50 greater than 50%. That has to do really with psych, now that I think about it. I think causation could be under 50% for, let's say, orthopedic. Someone could have a bad back and then a little bit worse because of their job, but we're really talking about the injury. That's complicated. It's the causation of the injury, and the injury could be the aggravation. So let's say that somebody is hired with a substantial psychiatric disability. Now they get depressed, and they have just a little bit worse at the end of the recovery and the treatment. Is that compensable? The answer is yes, because we're talking about just the aggravation, just the amount that's due, like I say up there, the aggravation. And if it's work-related to the extent of the injury, then it would be compensable. It's a direct causation. Usually indirect, no. It has to be directly caused by employment. Could it be contributed to by something else? Right, that's how we get into apportionment. Well, you know, he was lifting, he was digging holes, but he was also working in his garden. Well, then the doctor has to, who's examining, everything, by the way, is medically based. That's why I say doctor a lot. If the job did more than the gardening, or actually, even though, let's say he spent 10 hours a day gardening, 2 hours a day working, or digging at work, still there'd probably be a contribution of just the work injury, which would be the worsening. You see, so his back would have been so much if it was just due to the gardening, and this much worse because of the job. Is this theoretical and complicated? Sure it is. And that's why an attorney could probably find a very conservative doctor who'll say, nah, it's all due to the gardening. And another doctor who's more liberal, let's say, more worker-oriented, will say, no, it's 50-50. It's not like he said. Aggravation is when you have an accepted injury. Let's say you were hired with an injury, and then you get somewhat worse at work, and that's a new injury, believe it or not. That's considered a new injury, and it still has to be over 50% causation from the job. Causation is very complicated. But it means more or less the same as it does in personal injury. By the way, do you do many cases here outside of the criminal area?
Not really.
It's almost all
Dependency, but that's.
dependency?
Yeah.
Because I think I did one personal injury case when I was here, and the answer is 0 workers' comp.
Yeah.
I didn't have any lectures in it, and it's not considered. Dr. Pollack, the late Dr. Pollack, I know you've heard a lot about him. I think he didn't really consider workers' comp interesting, or, I mean, there was never anybody talking about it. So how did I learn about it? Well, I did it on my own. That's what I had to do. Let's see here, maybe do one more slide before break. Let's see what I got here. I got that one. Let's see, let me go the other way. There we go. Now, what is a presumption in workers' comp? Well, presumptions, I mean, I know we're here talking about psych more so, but if certain workers, like I have listed up there, police officers, and this again, it goes with the trade-off situation. If a firefighter goes to somebody's house and hurts himself when and the guy, let's say, fell asleep smoking cigarettes in his bed and he burned his house down, the fireman got hurt, you can't sue that citizen. And if you shoot a police officer, the police officer can't sue the guy who shot him. But there are certain presumptions, so he's traded that off for being a cop. But there are certain presumptions that they got, and I think it started about the 70s, I think, where if a police officer comes down with heart disease, or they call it heart trouble, or cancer, or TB, or hernia, I don't know where hernias got involved, firefighters, forest rangers, and correctional officers, if they get any of those diseases I have listed up there, hernias, heart disease, cancer, or TB, it's presumed work-related. And it's very tough to get rid of that presumption or defeat the presumption. Yeah.
So if somebody gets heart disease as a firefighter,
It's presumed work-related because it was something that was sort of like tossed a bone to them by the government. What if, yeah, I understand what you're thinking. What if he's got 4 brothers and they all died of heart attacks, and his father had heart disease? What if this firefighter smoked and was hypertensive and did skydiving and other stressful things? It can be argued, because presumptions can be, the other side can win, but it's a burden he's got to get over. But that's, and just recently Governor Brown tried to, I read about it, it didn't get through. He tried to make any serious infection, such as HIV or hepatitis, that was contracted by a nurse, presumed to be work-related. That might be a costly presumption, because who knows what else they're doing in there. And a lot of these diseases are very difficult to trace, right? How are we going to trace where it came from?
So many people have heart disease too. It's so common that it's, you know.
Well, again, it was given to them because they're presumed to have again, it's under presumption. The doctor really, his hands are tied. I mean, a good cardiologist who's very skillful at this can say, this police officer has family history, he's obese, you can't be too fat and be a cop, he's overweight, high cholesterol, now he's borderline diabetes, he's got the family history. I don't think it's work-related. I think work contributed just a little bit, not much. But it's very likely that he'll win on that.
That doesn't spread to other workers and like not nurses or doctors or.
Yeah, that's right.
People that are in the correctional system.
It hasn't yet spread. That's right. Like I said, Governor Brown was thinking about it, trying to put it through, and for some reason it didn't get through. There's a weird presumption too, and I don't know where this came from, but I read about it. You might read about it. If a worker unwitnessed is found at work on the ground with a bump on their head bleeding, it's presumed to be work-related. Now, I don't know why this man fell down, but they said with no other evidence, you have to err on the side of favoring the worker. That's the whole system is set up really to favor the worker, obviously. Some people say it's abused. Well, I'm sure occasionally it is, but no more so than, fender benders at stop signs and red lights. That's abused too. Why don't we, Trisco, take a break for, let's say for about 10 minutes, okay? And then if you have any more questions, and then I'll come back and finish up. And like I said, maybe you'll get some questions, okay?